Due Process, winner of 25 regional Emmy Awards. Due Process is a presentation of Rutgers University, Newark, and Rutgers Law School in Newark.
I was facing the rest of my life if I went to trial.
So innocent, but charged with rape, Rodney Roberts took a 7-year plea deal that became a 17-year nightmare till DNA finally freed him. The wrongful rape conviction, an all too common occurrence on this edition of Due Process. You're arrested for a crime. You're probably guilty. If convicted and jailed, most certainly so. At least that's what most Americans once believed. Some may still, but the last 30 years or so have challenged those assumptions, forced us to acknowledge that mistakes are made, innocent people are imprisoned, and sometimes even freed by the irrefutable evidence of DNA. The Innocence Project lists nearly 350 DNA exonerations. That's the good news. The bad is that it took an average of 14 years locked up before scientific evidence set them free. Case in point, Rodney Roberts. For him, it was even longer.
In 1996, I was falsely arrested and charged with the sexual assault and kidnap that I didn't commit.
And that was when the protections of the system should have kicked in. A more thorough police probe. No lineup.
No lineup. No anything.
A prosecution that should have made sure they had the right man.
I just was told that I was the guy.
A public defender in defense of his client.
He came in, and the first thing he started talking about was the plea agreement. And, I wanted to know if he knew my name, at least.
But Rodney had already been in the system, had stood trial as a teen for an earlier crime. Sure, the evidence then would acquit him. But a jury found him guilty. So when it all seemed to be happening again, this time with more serious charges.
I was literally feared for my life because they obviously had the power to push this through the system, even despite of the fact that I'm saying I'm innocent.
So he took the plea, 7 years in state prison, and finally maxed out on his way home.
I was ready to leave. My family was out waiting for me in the parking lot. And the day I was scheduled to go home, they were like, well, you can't leave. I'm like, what is going on? What you talking about? I can't leave.
They were talking about what was then a new state law, one still in effect today, the Sexually Violent Predator Act, providing that the state, once the sentence had been served, could continue to hold a man that the state deemed too dangerous to release. A new kind of imprisonment with a more benign name, civil commitment.
I just knew for sure that this was I was being punked or something, but they were very serious.
And he would remain there, in a separate section of the same prison, a so-called special treatment unit, for 10 long years.
They civilly committed me.
Sexual predator.
Right. The term itself is so horrible.
So for an innocent individual who has been failed by the criminal justice system, the injustice of civil confinement is mind-blowing.
Because although he had said he was guilty in order to get the plea deal, throughout his imprisonment he insisted he was innocent. That's what kept him from getting parole, made him a candidate for civil commitment, and made it likely he would stay locked in indefinitely.
It is completely unacceptable that a person who has been failed by the criminal justice system would find themselves not being able to ever have a path to regain their freedom because they're asserting their innocence.
But for Rodney, there was a path, one he carved out largely for himself through long years of legal study and pro se court petitions.
That was my way of fighting back.
Sometimes with a lawyer's help, more often on his own.
I filed a post-conviction relief pro se.
And that led to the first breakthrough, an investigator's interview with the victim who denied she'd ever identified Rodney and denied he had been the rapist.
So we thought that was going to be enough.
But it was not. Neither judge nor prosecution would budge, so there was just one more chance. DNA could clear him, and a new court-assigned post-conviction lawyer would help.
And it was clear in this case we had some evidence that a rape kit was done and DNA was extracted.
But it was lost.
But it was lost.
Until a new prosecutor joined the search.
And that's really where this newly discovered evidence came from.
Evidence that was tested at last.
Their expert from the New Jersey State Police Labs came back conclusively that it was not Rodney, and it couldn't be.
So after 17 years of unjust incarceration, Rodney Roberts is now free, even featured in a new campaign from the Innocence Project about why confessions may not mean guilt.
Innocent people plead guilty not out of ignorance, but out of fear. I mean, you are afraid that you're going to lose the one thing you want is your life.
But after 17 years of being innocent and locked up, what do you do about the bitterness and the rage?
I just don't have it in me. I gave it away. It's there. It's still there. All the anger is still in that cell. You know, it's still getting 3 hots in a cot. It's not out here in society with me. And if it is, it's expressed in a positive way. Just trying to help someone with any legal issue. That's where my anger is at. Is at the fact that the help. And that's the best way I could describe it.
And Rodney will be with us next week here in the Rutgers Moot Courtroom in Newark for the second of 2 shows, an in-depth look at the civil commitment suffered by him for 10 years. One of more than 700 in the last 17 years just here in New Jersey. They've served their time but stayed locked up. But this week on Part 1, our focus is on the many wrongful convictions, especially for rape, those overturned and those not. With Dr. Matthew Johnson, a psychologist at John Jay College of Criminal Justice, and Professor Laura Cohen, Director of the Criminal and Youth Justice Clinic here at Rutgers Law School. Welcome to you both. Let me begin by asking you, Matthew, you have dealt, at least since his release, with Rodney. And what has that given you in terms of greater insight as to what happens to somebody who's locked up for 17 years, innocent?
Well, I met Rodney, I believe, in 2015. He'd been released about a year at that point. I was fortunate enough to meet him, also to meet his wife. And frankly, to meet Rodney and converse with him, you wouldn't recognize or you wouldn't realize the type of what he's endured. He really carries it very well, extremely well.
Yeah, actually, It reminds me of one of Laura's clients, David McCollum, who seems to be almost Zen-like in his affect, but who went through a similar horror. Homicide case, not rape case, but the same kind of thing. These things are not so unusual.
They're not so unusual, and the coping abilities of many people aside, what they suffer both during their time of incarceration and when they get out is almost unimaginable. So even in the cases of people who, like Mr. Roberts and Mr. McCollum, have managed to get out and navigate life and somehow seemingly recover, they still face the incredible barriers of employment, of having lost so many years of their lives, of having seen decades of progress go by that they weren't part of, having never used a cell phone in some cases. And so the challenges are enormous, the Interpersonal challenges are enormous, and I think that what people lose from being wrongfully convicted can't be calculated by those of us who have never had to go through it.
This case raises so many of the defects in the criminal justice system, and one of them is the shocking number of false confessions. We perhaps should not be shocked, since we know that 98% of cases are a plea bargain and are not, in fact, ever tried. And yet, every time we see another case like this, there's someone who's likely to say, well, the person pleaded guilty. Obviously, that's the case.
Well, obviously, with our plea bargain system that's operating in the United States, and such a increase every decade, a larger and larger proportion of criminal trials are disposed of by pleas, and the severe penalties that are associated with trial convictions, there are a substantial number of people who are innocent who take pleas, and it begs for reform. But hopefully, there's a greater recognition of the fact that you cannot assume because someone took a plea that they were in fact guilty.
Laura, why do they take those pleas?
Oh, the reasons are innumerable. So the first thing that we have to remember is that the system is set up to encourage pleas. As you mentioned, Sandy, 98% of criminal cases that lead to conviction in this country are resolved by guilty pleas. That is about 4 times the percentile in other developed countries such as Italy.
In fact, our whole system depends on it.
Our whole system depends on it. It would crumble on top of itself, or alternatively come to a standstill, if we didn't have the level of plea bargaining that we have. So why do people take guilty pleas? Why do innocent people take guilty pleas? As Dr. Johnson mentioned, there's the threat of almost unimaginable sentences awaiting at the other side if they go to trial and lose. But beyond that, the systemic pressures are enormous. The overtaxed, overburdened public defense system in this country forces many public defenders to counsel their clients about the advisability of taking a plea or not taking a plea.
As apparently happened in this case.
As apparently happened in this case. So what we know about Mr. Roberts is that he met the public defender one time on the same day that he entered his plea.
And as he says, I didn't even think he knew my name.
Exactly. And beyond that, the system is set up to prevent people, the public defenders and the defendants, from obtaining discovery before they have to make that critical life-altering decision as to whether they take a plea or not. So the public defenders don't have a chance to review the police reports. They don't have a chance to interview the witnesses involved. They don't have a chance to engage in the measured calculus that any of us would want.
And they have 100 other cases waiting.
And they have 100 other cases waiting. And yet the decisions that are being made with their counsel have these profound and truly life-altering impacts on the people involved. And then there are other things as well. There's enormous systemic pressure to resolve cases as quickly as possible, to push people through the system, to dehumanize them, to turn them into numbers rather than people, and to not give them the individualization that is so critically important.
So how does a psychologist look at this and square it with how we say we feel about ourselves and our system of justice and fairness?
Well, I want to say a couple of things about this. Hopefully, I don't know if this is a psychological perspective or whatever, but I want to add that when we're talking about defendants that are facing rape convictions, that there's a tremendous amount of stigma that comes with the rape charge. People are unwilling, and it may, and I'm sure in many cases it even involves defense attorneys, are unwilling to really forcefully defend people who are charged with rape cases.
Because even a defense attorney tends to think if you were arrested for it, you probably did it.
And if it's a horrible offense, it puts an additional burden on a defense attorney. Also with rape cases, and as you know, that rape cases are predominant among wrongful conviction cases. There is a tremendous amount of pressure, oftentimes, on the police and prosecutors to get a plea or a conviction.
As David Shepard once said to me, they needed somebody, they got somebody.
Yeah. So,
and he wound up spending 12 years in prison.
And that's not unlike what we see here with Rodney. So you have these a variety of convergence of factors that make these defendants particularly vulnerable.
And it is the more vulnerable people in this society who wind up facing this dilemma. If you are, even from a middle-class family with maybe a house that can be borrowed against, and you've got somebody who's supporting you with a good private lawyer, you've got a better chance of, especially if you're innocent, of trying to prove your case. I think when Rodney says, I was told that I'd go to prison for the rest of my life, or I could take a lesser plea. He didn't plead to the rape. He only pled to the kidnapping. And so, he thought, well, I'll do my time. He had been in prison before, and we should admit that it was, he says that he was not guilty, but in fact it was also a sexual assault charge.
Yes.
That's part of what puts him in such a vulnerable position and lets him know that he could actually get life. Right. Of course, he doesn't count on civil commitment.
Sandra, I want to add something else about the rape charges, because as I noted a few moments ago that rape cases are predominant among wrongful convictions and exonerations, but actually it's not rape charges in general, it's specifically stranger rapes. Stranger rapes are less common. Most victims of rape are raped by people that they knew, and family members, acquaintances, and so forth and so on, about 75 to 80%. So it's really like a small proportion of cases, the stranger rapes, which are very burdensome on the police investigators to solve, because if somebody's attacked by a stranger, there's no clear connection in terms of the motive. The victim is often encounters difficulty with reliably identifying a stranger assault, particularly if there was a weapon, or if it was...
and particularly if it's cross-racial.
Particularly if it's cross-racial, exactly. So
which it wasn't in Rodney's case,
it wasn't in his
but
case,
particularly
yes.
there.
So you have a situation where there's a tremendous... the police are under tremendous pressure to try to close the case, and oftentimes the victims are not able to help them because they can't reliably identify them. And this really opens the door for coercion, for misconduct, and things of this type. And this is a series of elements that we see often in, you mentioned David Shepard, Rodney Roberts, other cases in New Jersey, Nate Walker.
Maybe the most famous of the false confessions came from the Central Park Five.
Right, of course.
Yeah.
Also a rape case.
Yeah.
Right.
Also a rape case, 5 kids. They were said to be wilding, out looking for trouble in the park. Maybe looking for trouble, but as DNA finally proves after years in prison, after terrible experiences, and talk about being shunned by the world. I mean, they were looked at as being the scum of the earth.
Yes.
Right.
They're cleared.
But what we know about the Central Park case is that in addition to the problems of identification, because the victim in that case couldn't possibly have identified.
Identification wasn't involved.
But what we also know about that case is that all of those young people were young people. And they were uniquely vulnerable to the kinds of coercion and overreaching that police investigators engage in when they're conducting interrogations. It's the same thing that we saw recently in the Making a Murderer Brendan Dassey case.
Yes.
That wasn't an issue in Mr. Roberts' case, but it certainly is in a substantial percentage of wrongful conviction cases. And young people are substantially more likely to be wrongfully convicted because of false confessions than adults are. And for adults, it's 30% of exonerations involved a false confession.
Well, and when you're told, just cooperate, just tell the truth, tell what you did. You know you did this, this, and this. You can go home.
Right.
Yeah, I want to add something else about the Central Park jogger case. It's my understanding, and this is linked to Rodney's case as well, but it's my understanding in the Central Park jogger case that about 36 hours after they found the woman's body, Patricia Malley's body, they had confessions from 4 of those juveniles. And the case was over. Right. The case was over.
Right.
It had been it was mishandled. The actual perpetrator never came into the view, but it was mishandled in a short period of time. Everything after that was pretty much pro forma, how it was going to go down. And it illustrates, similar to Rodney Roberts' case, that the detective who apparently falsified this identification procedure, that once that is done, the rest of the system is not capable of correcting the error.
Yeah.
And the error just gets ratified and ratified through arrest, through trial, through, then they go into prison and it's on their record. And it's like the people in our system, they're not able to self-correct an error. Only Mr. Roberts himself
That's
working,
right. I was
who's not
going to say,
educated.
every case that I know of has involved someone who maybe had never read a book before, but winds up finding the law library and fights and fights and fights, and ultimately gets someone to fight with them and for them, and otherwise you're lost.
And we see that time and again, that in order for someone to bubble up to the top, as it were, and obtain the legal help they need, they have to start out by being good advocates for themselves. And so we see people like Mr. Roberts and Mr. McCollum, for that matter, who became educated in prison, who learned the law while they were in prison because their legal advocates on the outside were not doing it for them.
Right, so is part of the problem that we don't have proper post-conviction relief?
Absolutely. And not just that we don't have proper post-conviction relief, but in addition to that, that there really is not access to counsel for post-conviction relief applications unless and until you've crossed that barrier and convinced a court to appoint you counsel. And that requires you to make the case for yourself in order to get the help you need to make that case.
Because, again, the system has finished with you, doesn't want to be bothered with you again, doesn't want to bring your case back up, and therefore the quest for justice that we would like to think governs things gets pushed to the side.
So there's a tremendous emphasis throughout the legal system on finality of judgment. And it is at the expense, often, of the truth. And we've seen that here. It starts with the police investigation. It starts with the devotion of the minimal amount of resources necessary to make an arrest that police officers think will stick. It goes through the desire of prosecutors to, if possible, ratify that decision on the part of the police. And then the legal system itself, the judicial system, the appellate system, places a heavy emphasis on finality. There is no ground to vacate a conviction because we got it wrong, except in extreme situations. Yeah. Actual innocence in most states is not a ground to vacate a conviction, and the Supreme Court has held that.
So this is really a flaw that doesn't just affect a few people.
No, not at all.
I mean, we've talked about the more dramatic cases, but this is happening every day.
Every day.
The cases we know about. I mean, and obviously
the cases we know about.
As you were saying, the extraordinary efforts by certain of these defendants, they're able to garner the resources to establish innocence. But I mean, how extraordinary do you have to be? I mean, how many other people have been wrongfully convicted that we can't put our fingers on?
And with about 30 seconds left to go, the psychological damage to these people?
Well, the psychological damage is going to be profound and extensive. And I know in Rodney's case in particular, I mean, he not only suffered the 18 years in prison, part of that time he was in solitary confinement. I mean, as I said initially, to meet Rodney and to talk to him, he does not wear his scars on his sleeve. But I know from things he has confided in me that he continues to be troubled is an understatement in terms of what he lives with in terms of the trauma and so
just
forth.
The last word, Laura, with 10 seconds to go. If you could change the system in one profound way that would help, what would it be?
Ensure that everyone has access to a lawyer who has, from the beginning, in the station house when they're being interrogated, who has the time, the energy, the resources, and the commitment to prevent these things from happening.
With my thanks to Dr. Matthew Johnson and Professor Laura Cohn. That's it for this edition of Due Process. But you'll want to join us next week back here at Rutgers Law School for part 2 of our report, an in-depth look at civil commitment with Rodney Roberts, who's lived it, and Jenny Brooke Condon, who has struggled to make it more humane. Till then, for producer Tanya Bentley and all of us here, I'm Sandra King, and we'll see you next time.
What DNA has proven to us time and time again is that people confess falsely. And they confess falsely for all kinds of reasons. They confess falsely because of police coercion, sometimes because of police physical abuse. The Innocence Project has documented over 300 people now who have been exonerated through DNA testing, and then probably 3 times that many whose convictions have been established in court to be wrongful convictions. So we know this happens over and over again. Police rushing to judgment, inadequate investigation, all of these things come together, leading to what I think is really almost surely an undercounted number of wrongful convictions in this country.
Want even more insight on law and justice? Become a fan of Due Process on Facebook. Follow us on Twitter and watch us on demand on YouTube.